Hello, my name is Jennifer Venieri. I'm an attorney licensed in 6 states, and I also am a college instructor. This video is designed to be really for informational purposes only and not to give legal advice, but to help people out to understand some common legal terms that are sometimes confusing. So will versus living will versus living trust. Easy ways to remember these terms. So first for the legal definitions. A last will and testament, or a will, is a written document that leaves the estate of the individual who signed the will to the named persons or entities. A will only takes effect upon the maker's death and can be revoked or amended at any time while the maker is still alive. A will usually appoints an executor, which is also known as a personal representative in some states, to manage the estate and carry out directions in the will. In addition, a will may nominate guardians of minor children and may even give funeral or burial instructions in some states. So a living will, on the other hand, is a written expression of a person's wishes to be allowed to die a natural death and not be kept alive by heroic or artificial methods. So this is a document designed to inform your healthcare providers what you want. And then a living trust. Other names for a living trust include inter vivos trust, which is Latin for meaning within one's life. Also revocable living trust, which is a trust that's created and becomes effective during the lifetime of the trustor. Another word for trustor is settlor. Living trusts commonly provide that the trustors receive the benefits of the trust during their lifetimes, followed by a distribution to the beneficiaries after death. Living trusts are commonly used in estate planning and can be amended or revoked during the lifetime of the trustor in accordance with the provisions of the initial trust document. So in order to be effective, property has to be placed into the trust with title handed over to the trustee following the signing of the document. Living trusts are typically used to try to avoid probate. Okay, so all of that was a mouthful. That was kind of high-level legal definitions. Now for some plain English definitions. First, the definition of will, once again, simple definition. It's a written document that leaves the estate of the individual who signed the will to the named persons or entities. So, how to remember the term will? When your family members think of this document, they might be thinking, will you leave anything to them? So once again, what will the will say, and will it leave anything to them? Next term, living will. Once again, the legal definition, a written expression of a person's wishes to be allowed to die a natural death and not be kept alive by heroic or artificial methods. One way to remember it, according to vocabulary.com, will means to want or to choose. So if you have free will, you're allowed to choose what you want. So in this context, your living will, it's a document that directs what you want or choose for your medical care while you're still alive. So while you're alive, do you want to receive continuous artificial nutrition and hydration if you're in a persistent vegetative state or coma? That's something that this document typically directs one way or another about. Okay, so last, living trust, also called an inter vivos living trust, a revocable living trust. Don't be confused, they're all words that mean the same thing. It's a document that's created and becomes effective during the lifetime of the trustor, and people who execute this document are usually trying to do so to avoid probate after they die. So one way to remember it, it contains the word living, so you know that the document becomes effective while you're still alive, and you have to trust that your wishes will be carried out as stated in the document after you die. So this is because trust administration is typically not overseen by a court. That's the point of the trust, is to settle your estate outside of court. So do you trust your successor trustee to carry out your directions? So usually that's your family. Do you really trust your family to do just as you've said after you've passed away? If so, perhaps a trust is appropriate. So this was just some simple estate planning terms in plain English. Hopefully they helped out.